Okay, welcome to another episode of Bar Exam Drills. It is 5:01 and it's time for me to get home and figure out what's for dinner. So that being the case, this is going to be a very quick and dirty video. So the legal concept we're going to talk about today is estoppel by deed. And sometimes it has another name, and that other name is estoppel by deed, also known as acquired after title. Thank you so much, Wikipedia. So this video is sponsored by Bar Exam Drills. Bar Exam Drills is an amazing app that has over 2,000 licensed MBE questions to help you to prepare for the bar exam. If you are taking the bar exam, you need to get this app. It costs less than $1,000, and it is a great way to just jump in there and get familiar with bar exam questions. We also want to give a special thank you to the Marchica Law Firm in Vermont. Marchica Law Firm is my supervising sponsor, and they are helping me to learn the law on my own in preparation for taking the bar. In 3 years and 2 months, I will be finished with my law office study program. So time is ticking. I can't believe it is almost time for my second report to the state of Vermont. So estoppel by deed. Estoppel by deed is a doctrine that precludes individuals from arguing in court a position counter to what the person stated in a previous deed. So the doctrine arises most frequently where someone deeded property they did not own. That's not good. And later they're involved in a dispute involving that property. For example, John sells Parker 50 acres of land behind John's house for $200,000. But John actually owned only 30 acres of the property, and there's another true owner of the 20 acres. So Parker would only have legal ownership of 30 acres of land John owned. Estoppel by deed would prevent John from arguing in court that Parker did not own the other 20 acres in any legal dispute because, while true, John purportedly sold the property to Parker. So let's just look and see what Wikipedia has to say about it. Estoppel is a common law doctrine which is applied when estoppel is a common law doctrine which, when it applies, prevents a litigant from denying the truth of what was said or done. The doctrine of estoppel by deed, also known as after acquired title, is a particular estoppel doctrine in the context of real property transfers. Under the doctrine, the grantor of the deed, generally the seller of a piece of real property, is estopped or barred from denying the truth of the deed. The doctrine may only be invoked in a suit out of the deed or involving a particular right arising out of the deed. While rooted in warranty deeds, estoppel by deed has been extended to affect quitclaim deeds if the deed represents that the grantor actually had title. So here's an example. If O conveys a property she does not own to A by warranty deed, but O later acquires title to the land, then title immediately passes to A. However, if, as above, O conveys property she does not own to A by warranty deed, but O later acquires title to that land, A may elect to treat O's lack of title at the time of the conveyance as a breach of the covenants of Stasian and right to convey two of the 6 traditional forms of covenants for title that are contained in a general warranty deed, and sue O for damages. A cannot be forced to accept O's after acquired title if she wishes instead to receive damages. If O conveys property she doesn't own to A by quitclaim deed, but O later acquires title to the land, then A owns nothing. This is because O passed her interest to A with a quitclaim deed. At the time of conveyance, O's interest was nothing, so she passed nothing. So there you have it. This is really good. I love these examples, right? So if I convey a property that I don't own to you by warranty deed, if I later acquire the title to that land, then the title immediately passes to you. However, if, as in above, I convey property that I don't own to you by warranty deed, and I later acquire the title of the land, you may elect to, instead of accepting the land, to sue me for damages. Now, if it's quitclaim deed, it's very different. If I convey property that I don't own to you by quitclaim deed, but I later acquire title to the land, you own nothing. Because when I pass my interest to you with a quitclaim deed, at the time of the conveyance, I didn't own anything. So I passed along nothing. You got to make that nothing burger. And so that is our quick and dirty video before I get out of here and I make dinner tonight. Think we're going to do chili dogs again, but I mean, it's a Wednesday. So, with that being said, thank you so much once again, Marchika Law Firm, for helping me on this journey to pass the bar without going to law school and become an attorney in the state of Vermont, and also to Bar Exam Drills, that is giving me everything that I need to be prepared to take the bar exam. You need to get the app. It is a great app. You can use it anywhere. It has videos for many of the questions that explain them, more than 2,000 actual licensed MBE questions at a price you can't afford to pass up. Thank you so much for tuning in today, and we'll see you again soon. Bye-bye.